Hi everyone, welcome to video lecture 6 on securing compliance with ASEAN law and institutions. So we will continue the theme that we saw in seminar 5 on the same topic, where we looked at the theories of compliance and why and how states obey international law. Moving on this week to the ASEAN context, we look at the Eminent Persons Group report and see the mechanisms that they have come up with regarding improving compliance in the ASEAN organization. So as we remember, the Eminent Persons Group report said that compliance in ASEAN needs to be improved and improved by quite a lot. So the EPG said that there are two main ways to secure greater compliance with the laws and rules of ASEAN, and the first way is through establishing dispute settlement mechanisms in all areas of cooperation in ASEAN. And to a lesser extent, the Eminent Persons Group also said that, monitoring mechanisms are also very important for securing compliance in ASEAN. So let's look at the main mechanism, which is the dispute settlement mechanism that we have talked about in previous videos. So in Chapter 8 of the Charter, this looks at all the dispute settlement mechanisms in ASEAN, and let's see how these mechanisms can secure better compliance in our regional organization. So the first article of Chapter 8 is Article 22, which sets out the general principles of compliance in ASEAN or dispute settlement in ASEAN, and says that, if we ever have a regional dispute, everyone should resolve the disputes peacefully through dialogue, consultation, and negotiation, right? And then the second point is that for maintenance of peace, security, stability, and economic development in the region, or for ASEAN community building, ASEAN shall maintain and establish dispute settlement mechanisms in all fields of ASEAN cooperation. And we really need to connect, Chapter 8 with the 2010 protocol to the ASEAN Charter on Dispute Settlement Mechanisms, because this Chapter 8 dispute settlement provisions are elaborated in the 2010 protocol. So please do have a look as given in the seminar sheet. Now let's look at more substantive areas of dispute settlement in ASEAN, right? So the idea is that the Eminent Persons Group thought that once we have dispute settlement mechanisms, these enforcement mechanisms will act as a stick rather than a carrot that we saw in Seminar 5. So enforcement mechanisms in Seminar 6 will be the stick that compels and forces ASEAN member states into obeying, into complying with ASEAN law. So let's see what these dispute settlement mechanisms are. The first one is looking at the alternative dispute resolution mechanism in Article 23 of the Charter. So first port of call, first recourse to settling disputes is that we need to look at dialogue, consultation, and negotiation, and all good offices, conciliation or mediation. So we talk it out according to the rule of law. So it's not like pre-2007 where it's only discussion based on diplomacy. This alternative dispute resolution in Article 23 of the Charter, yes, we are using the same discursive dialogue mechanisms, but everything needs to be based on the rule of law, right? And then let's see, for economic disagreements, for economic disputes, if the economic treaty or the economic instrument has a specific type of mechanism to settle disputes, then Article 24.1 tells us that in the event of such an economic dispute, please let us have recourse to the mechanism specified in the instrument, right? So we don't need to look at external economic dispute mechanisms. Let's just first look into the instrument. If that economic instrument doesn't have an explicit economic dispute settlement mechanism provision, then ASEAN has a catch-all economic dispute settlement mechanism for ASEAN member states, and this is in the 2004 ASEAN Protocol on Enhanced Dispute Settlement Mechanism, right? And it says that if the treaty or the instrument doesn't specify a dispute settlement mechanism, the economic dispute can be arbitrated under the 2004 EDSM. Article 24.3 of the ASEAN Charter says this. For all other types of disputes, such as, disputes falling under the political security or the socio-cultural pillar, we have recourse to the Treaty of Amity and Cooperation. Article 24.2 of this Charter tells us this. So generally in practice, the TAC, the Treaty of Amity and Cooperation, is used generally for peace and security disputes. And of course, the EPG did say that, they want to establish dispute settlement mechanism for all types of cooperation and all types of disputes in ASEAN. So there is this catch-all clause in Article 25 of the Charter, which says that there will be dispute settlement mechanisms for all other disputes. So if they don't fall into the economic ambit and don't really fall neatly into the Treaty of Amity and Cooperation type of dispute, then Article 25 can be activated. And of course, if we go through all these dispute settlement mechanisms and we still cannot resolve the dispute, then we can go to the ASEAN Summit, right? So disputing parties may refer any unresolved dispute to the summit in Article 26. Let's look more closely at, the specific types of dispute settlement mechanisms. So the Charter has given us an overview, and it tells us where and which instrument to look for when we need to resolve a specific type of dispute in ASEAN. So first, looking at the political security and sociocultural community type of dispute, as we have seen, we need to have recourse to the TAC of 1976, right? So the TAC was the first regional treaty of ASEAN, and it told all ASEAN member states to resolve disputes peacefully, and there cannot be any use of force in the region, right? And this basically mirrors the UN Charter principles. The TAC, as I've mentioned, pertains mainly to political security disputes, and in the event that it occurs, sociocultural disputes can also be activated or resolved under the TAC. One thing that's quite special about the TAC is that although it's an intra-ASEAN treaty, non-ASEAN signatories are permitted. So in a way, the TAC is like an external treaty as well, and there are many non-ASEAN signatories. Now, how do we activate the Treaty of Amity and Cooperation? This is governed by the 2001 Rules of Procedure of the High Council of the TAC. So there is some uncertainty whether it's enforced, but I think by now it is enforced. Whether it has been activated after it has come into force, that is more questionable. Okay, so how do we use the Treaty of Amity and Cooperation? As we have seen in the ASEAN Charter, the Treaty of Amity and Cooperation upholds, the good offices, negotiation, mediation, so kind of like diplomatic discussions based on the rule of law, and then try to resolve the dispute that way. So via negotiation, the High Council will have consensus powers, and then there are good offices, mediation, conciliation, so on and so forth. There is no definitive time frame to settle the dispute, so it can stretch on and on. So to us as lawyers, I'm going to pose the question, is is this open-endedness of the Treaty of Amity and Cooperation desirable? And if you look at the 2001 Rules of Procedure and the Treaty of Amity and Cooperation, these two instruments, to what extent is the TAC a good mechanism to resolve dispute, or is it a weak mechanism such that if ASEAN member states have political, security, or socio-cultural type of disputes, should they use the TAC, or should they go outside of ASEAN to try to resolve those disputes? So such as the International Court of Justice, or so on and so forth, the PCA, so on and so forth. Looking at economic types of disputes, let's look at the 2004 protocol on the EDSM, right? So the 2004 protocol supersedes the 1996 protocol on the DSM, so only economic disputes should apply, and the 2004 protocol applies to most ASEAN economic agreements, right? So even though it's a 2004 protocol, there's some retrospective usage because 2004 protocol applies also to disputes under the 1992 Economic Framework Agreement for ASEAN, the covered economic agreements, and also, future economic agreements, right? So in Article 1 of the 2004 protocol, it says this. The 2004 protocol is modeled on the WTO mechanism, but with a shorter time frame of resolution. As usual, the first obligation in ASEAN dispute settlement is that we need to consult and discuss before we go to litigation, right? So you consult, discuss before you trigger adjudication. Now, even though the 2004 protocol follows the WTO, the time frame is shorter. The adjudicatory panel has 60 days to come up with recommendations. Then there's the appeals procedure to the appellate body. And then there are the enforcement procedures of, monitoring, reporting, data transparency, making sure that everyone is complying. And it also says that, if there's non-compliance with a tribunal decision, then the violating party, the violating state, should pay compensation. So in terms of the 2004 EDSM, although it looks very, very good, right, because it's basic and it's also a very familiar process because it mirrors the WTO, there are some technical or procedural issues to consider. Is it efficient? Is it effective to use the 2004 protocol, or should we go to external fora? Should we forum shop, like go to ICSID, WTO appellate panel, or should we just use the EDSM? And this is all very important because of the timing issues, the time frame issues, right? And also in terms of expertise, in terms of technical knowledge, perhaps intra-regionally we might know better. And sometimes there are also some hurdles. There may be issues of neutrality, perceived or actual, right? Or maybe if we go to the international stage, there might be a bigger pool of arbitrators, right? Arbiters. So these are all considerations. One thing to note about the 2004 protocol is that there has been in recent years, in the last 2 years, a new protocol signed to update this EDSM to give longer time frames, but it is unclear whether that new protocol is now in effect. So what are the key features of the ASEAN Charter type of DSMs, right? As we all remember, the EPG said we need to use dispute settlement mechanisms for all ASEAN instruments, and then we need to know, right? Looking at the questions, guiding questions in the seminar sheet, Chapter 8 of the ASEAN Charter has listed out all the individual provisions on different types of mechanisms specific to different types of disputes. And there is a catch-all general clause for dispute settlement mechanisms. And that the Chapter 8 is triggered, or rather implemented, by the 2010 Protocol on the ASEAN Charter and Dispute Settlement Mechanisms, right? And let's see where the Secretary General has powers regarding the dispute settlement mechanisms. It's not just about arbitration or negotiation, but we have outcomes of our settlement of disputes. We come to certain decisions. There are certain things that we need to do to prevent violations, to make sure that everyone complies. And to make sure that everyone complies means that someone has to observe, has to monitor. And so Article 27 of the Charter gives the ASEAN Secretary General the power to monitor compliance after the dispute settlement decision is out. So one question that I need to pose to everybody is that, when we look at the Eminent Persons Group report in the low level of compliance pre-2007 of ASEAN commitments, the EPG had full confidence in dispute settlement mechanisms to ensure obedience and compliance to ASEAN law. But is this really very true? If we understand what we have seen in Seminar 5, looking at Henkin, looking at Frank, the fairness in international laws and institutions, and looking at Chase and Chase about, the management or the managerial system, and lastly, looking at Harold Koh's theory of the transnational legal process, where the domestic system is very important also for ASEAN law or international law compliance. All these four theories that we saw in Seminar 5 go towards upholding compliance and obedience to ASEAN law. It's not just as easy or simple as the EPG says. Once we have dispute settlement mechanisms, compliance will be ensured. It is really not so easy. Let's look at what other experts say. So Karen Alter in 2003, her work. Karen Alter is a political scientist who studies international courts, right? International arbitral panels, and she's an expert. And she says, do we really need to have courts to make sure that we get compliance? And what's the importance of having, enforcement mechanisms like dispute settlement mechanisms? So Karen Alter says that apart from well-made laws, the presence of courts show that, we have a credible commitment, because it's not only good enough to show that the law is well made and that law can engender compliance, but the fact is that if there is the existence of, an arbitral panel, it demonstrates to the members in the region as well as external partners that these states are so committed to their undertaking, to their treaties, to the extent that they are willing to go to court to be sued and to have decisions or judgments enforced against them. So it really shows, courts have a very good signaling feature, right? And also going to the idea that, you can have punitive enforcement action via courts. So this could also deter cheating, because you don't want to have, a bad outcome against you, right, via the court. So the threat of having a court there or enforcement mechanisms could deter bad behavior, deter cheating. In certain cases, in certain types of disputes, having courts could neutralize politically sensitive issues, right? So, and the idea to this neutralization goes towards this rule of law idea, right? Big and small states are equal before the law. So whether one is a very small state, one can sue a bigger state, right, like what they do in the WTO, small states suing the big states for violations of trade law. So big and small states, when they rely on the law, they can go before the tribunal and are on equal standing, right? And courts also have an added benefit because it gives, when you go before the court, you engage legal experts and you also engage technical experts to show that your evidence, your substance is correct and show that why your claim before the court is correct, right? So there is some neutralization of political sensitive disputes if we go to a court to resolve those problems, right? But then I want to put a caveat there that not all disputes can have their political sensitivity reduced by just going to a court. I will talk about that later, but please bear this in mind. Another advantage of having courts or dispute settlement mechanisms is because, sometimes when our agreements, our international agreements are too large for monitoring, right? So let's think of the GATT agreement, the WTO agreement, such mega trade agreements, it's not so efficient and not so effective to keep monitoring. So if we do not have recourse to monitoring mechanisms, the threat of going to the court for enforcement could encourage compliance, could deter cheating, okay? Right? But then lastly, Karen Alter, because she's a political scientist, so she knows she can see beyond the law. And what she says goes very much hand in hand with Chase and Chase, because she says that it's not just by having courts we have better compliance, because there are serious issues of capacity in compliance, right? So if member states don't have capacity to comply, even if you force them to the court and give a decision against them, and you have this enforcement action against them, if they don't have the resources, have no capacity to comply, no matter what legal decision, judicial decision you have, they are still not going to comply, right? And sometimes, even if we have courts, there are regions in the world or states in the world, in the international community, that don't have a litigious culture. There's no litigation culture, right? So, and in such a context, if we think about ASEAN, where the ASEAN way previously was non-legalistic, and so they didn't sue one another, and still this lower litigation culture is also very much of the ASEAN environment. So if we are faced with this lower litigation culture, even if we have the courts there, it's not going to do so much to engender compliance, right? And another drawback to dispute settlement mechanisms regarding compliance is that some issues are just too politically sensitive. So even if we have arbitral panels and dispute settlement mechanisms, states will not bring such disputes to the international court, to the regional court, because the stakes are too high. If you lose at the international level, at the regional tribunal level, you're going to, you don't want to lose control, right? So the sovereignty stakes are too high. So this is perhaps one reason why territorial disputes where sovereignty stakes are obviously very high, we don't use ASEAN dispute settlement mechanisms so far to resolve them. And also, although we still have many territorial sensitive type, political sensitive type of disputes in ASEAN, not only do we not bring them to ASEAN dispute settlement mechanisms, but it is infrequent that ASEAN member states bring these politically loaded cases before international tribunals. So it's not like every day we bring a case before the ICJ or ITLOS or other international arbitration panels, right? So Eric Votan in 2010 also talks about this, right? He and Alter concur that for less politically loaded disputes, so generally like trade and investment disputes, where it's more technical, states are more willing to use dispute settlement mechanisms, right? But when it's more politically sensitive, when the stakes are much, much higher, then international tribunals are much less used, right? But Eric Votan has a further thing to say about economic disputes. He says, yes, regional economic courts, regional economic tribunals do bring about greater compliance because this is not their most primary or effective contribution. What will force greater compliance is that private parties using, perhaps domestic courts, right? Private parties. So private parties are like individuals. So only states, because they're international persons, can use the state level type of courts, right? The regional economic tribunals or international courts. Only states can use it. But if we think of our domestic jurisdiction, those who bring on the economic cases, the finance cases, they're all, private actors. Private actors want to sue for damages. So really, where we see most activity to be able to push compliance, it would be if these private parties could trigger economic dispute settlement mechanisms. So presently, private parties cannot trigger ASEAN economic dispute settlement mechanisms, but if we trigger them at the domestic level, the courts will be able to push greater compliance and integration. Okay, so this was actually played out in a moot competition in 2018 during the ASEAN Law Association conference, where ASEAN law, when it translated to national administrative law, was litigated, and one can see how private parties using the courts can push compliance and integration. So if we see, that dispute settlement mechanisms, whether for political security and sociocultural versus economic types of disputes, are less used in ASEAN, is monitoring a better way to encourage ASEAN's compliance, right? So up till now, since the EPG in 2007 said that, we really think that having dispute settlement mechanisms will increase compliance, but up to today, 2021, we don't see that happening. So is monitoring, the secondary way that they suggested, is that now becoming a much better way to encourage ASEAN compliance? So let's explore this together, right? So we know through the ASEAN Charter and in our previous video lectures and the seminars that the Secretary General and Secretariat have the rightful powers of monitoring and reporting. And this could involve data collection and performance reviews, annual reviews of what the member states have done, where they are falling short, what are the capacity limitations, and what else they need to improve their compliance, right? So all this would go towards greater transparency, information sharing, allocation of resources, and training, right? So all this helps the capacity building function. And also, as we all have studied, that the fully functioning ASEAN legal service could play a critical role in enhancing compliance alongside the Committee of Permanent Representatives and National Secretariat. So basically all the civil servants at the ASEAN Secretariat level and the ASEAN member state level, they have, they are the implementers of ASEAN agreements, of ASEAN soft laws, so they should be the ones keeping an eye on ASEAN compliance, ASEAN monitoring. So where does that bring us? If these are the people and the structures that will help move monitoring mechanisms in ASEAN. So let's track where these regional obligations are. In 1976, the agreement to establish the ASEAN Secretariat, the monitoring mechanism was given to the Secretariat in Article 3.2, right? From 1976 to 1992, there was a huge omission for monitoring mechanisms, although in this period, dispute settlement mechanisms, although they were quiet, but they were included in some economic agreements, right? So for 76 to 92, there was very little voicing out or emphasis of the monitoring mechanism of the ASEAN Secretariat and of the ASEAN Secretary General. In 1992 to 2006, right before the Charter, the monitoring mechanisms increased in the ASEAN economic instruments, but although the legal provisions increased, but the practical effect of the Secretary General and the ASEAN Secretariat were lackluster. So law says one thing, practice says another. Practice is basically silence, right? So what were these monitoring mechanisms in the early years of ASEAN? It was, for the economic instruments, it was the ASEAN Economic Ministers and the Senior Officials Meeting, the Senior Economic Officials Meeting, right? And then in the 1998 notification procedure, right? So how do you notify what is being done regarding the economic instruments? And then also there was a reporting mechanism as listed in the Bali Concord too. So these are the early monitoring mechanisms of ASEAN. In 2007, through the EPG report, the EPG said that, to a certain extent, we need to have greater compliance monitoring, right? So the million-dollar question is, who has overall oversight and coordination? So this goes back to our rule of institutions seminar, right? To have oversight, to monitor, to report. These are strong functions. They're bureaucratic functions, right? Technocratic functions, not political, because we're just trying to see, hey, member states, you said you would do something, we check whether you are doing, right? There are certain instances where there are expert monitoring bodies, especially in certain ASEAN economic instruments, but, we cannot have a conflict in monitoring bodies. We cannot say that we give the monitoring powers to a certain expert body and then keep silent on the Secretary General's monitoring role. How can we override the Secretary General's rightful powers from the 1976 agreement all the way down to the power given in the ASEAN Charter, right? So the ASEAN Secretary General has the rightful power of monitoring. So it is not right to exclude the co-sharing of powers is better. Right? Where the Secretary General is supposed to submit this monitoring report, annual report, on how much the ASEAN community milestones have been achieved. It is uncertain whether these reports are submitted. Yes, I think increasingly yes, the regularity, but in the earlier years, it might have been a little spotty. And one thing that we need to bear in mind is that as we move, ever since 2016, ever since the establishment of the ASEAN community at the end of 2015, the towards 2025 blueprints, roadmap for the ASEAN community tell us that monitoring is very, very important. And ever since 2016, monitoring bodies are established in every pillar of the ASEAN community. So if you look in the ASEAN Secretariat website and the organizational chart, there is a monitoring body under every pillar. So there are 3 pillars in ASEAN, there are 3 monitoring bodies, right? So there is much more robust substantive monitoring, regular monitoring that is being carried out now. And I think the greatest focus is on obviously the ASEAN Economic Community monitoring. So this is the most developed mechanism. It was developed prior to 2015 with the help of the World Bank and Australian aid on increasing the scrutiny on ASEAN commitments and making sure that the member states keep on track, right? And so now this has morphed into the ASEAN Integration Monitoring Directorate, right, the AIMD, which administers and monitors and tracks the ASEAN Economic Community 2025 growth, right? And the substantive framework that this AIMD uses is the Monitoring and Evaluation Framework, so the M&E framework. This M&E framework works in 3 ways. First, there is compliance monitoring, right? So it checks whether the ASEAN member states actually do what they have committed to. So you need to see that there's quantitative and qualitative data, right? So qualitative data is via interviews, quantitative is to look at the data reports and so forth. And then there's compliance monitoring also needs to see whether, there is actual implementation. So, we cannot have dead laws, we cannot have dead policy. The AIMD wants to see that there is actual action taken pursuant to the domestic legislation, domestic policy. So this goes to Seminar 5, post-transnational legal theory, right? And country visits are part of this new protocol. So not only does it track compliance, number 2 of this, so compliance is check whether they do it, right? And it's not enough to do, because the second step in the M&E framework is that after you do, we must see real outcomes. So it needs to see practical outcomes and economic indicators, because ASEAN community building is supposed for the prosperity and development for all. So we want to see our efforts resulting in positive outcomes. Are we getting, greater GDP, right? Or GNP? Is the standard of living better in every ASEAN member state? Are salaries rising? So these are the outcomes that they monitor. Then lastly, people are important, right? So it's not just like, GDP, economic growth, all at a very abstract state to state level. It means the impact evaluation really looks at people, like us, citizens. Are we benefiting from ASEAN economic community building? So this M&E framework will track the positive and negative integration effects and to ensure that there's equitable development in ASEAN societies. So if you want to see this in greater detail, check out this URL. So let's now come to the final slide, looking at the rule of law in institutions and understanding what we have seen in today's video lectures, tracking the EPG report, tracking what has been done throughout ASEAN's history pre-2007 and what ASEAN has been doing ever since 2007, especially after, 2015 with the establishment of the ASEAN community. Are the DSMs and the MMs that we have enacted, we have established, which of them are more helpful to bringing about the realization of the ASEAN community. So the bigger question that I want to come back to is, are dispute settlement mechanisms really helpful as the EPG envisioned, and are DSMs as helpful as we see in the rest of the world? Because they think that regional integration relies a lot on tribunals. But in ASEAN, because we have not used the tribunals, and ASEAN member states want to use a different way of making sure that their regional integration works, how are we going to move the debate forward, right? So all ASEAN dispute settlement mechanisms are ad hoc. They exist, but you have to activate them, right? And none have been used fully so far. So the million-dollar question is, will they be? I think one thing to bear in mind is that even if they have not been used so far, dispute settlement mechanisms, we cannot rule out them being used in the future. And what would catalyze, the triggering of dispute settlement mechanisms? And generally speaking, lawyers, especially and political scientists, have also queried the importance of dispute settlement mechanisms in encouraging compliance. So if I can put an international law example out there, that even if we do have international law outcomes, there are many instances, right, that states still do not comply with the international tribunal's ruling. So in such a situation, if we think about it analogous to the ASEAN situation, perhaps monitoring mechanisms could be more useful, helpful, right? Because it tracks on a more regular basis, and before it can escalate to a violation, could escalate into a very heated dispute, monitoring will say, hey, you have not kept to your target, and everyone else knows this, and you are actually able to keep up. Please keep your work going, right? Please catch up. Okay? And then lastly, I want to say that if we are going to have a rule of law and a strong rule of law and strong rule of institutions, there are other issues which need to be addressed, right? Rule of law, rule of institutions, they do not exist in a vacuum. We need to have better lawmaking. We need greater resources and capacity. We need to have a stronger centralized secretariat, right? And this stronger centralized secretariat doesn't diminish sovereignty, right? And then at the Harold Hongju Ko level, there needs to be national implementation, and there needs to be support for public agencies and civil institutions. So if we return to the EPG question on having dispute settlement mechanisms and to a lesser extent monitoring mechanisms for greater compliance of ASEAN law, I think that vision is maybe too simple. We need to have a much more robust, much more multifaceted approach to supporting ASEAN member states, ASEAN institutions in getting greater compliance, obedience to ASEAN law and institutions. Thank you very much.